It was 1188. Ranulph de Glanville, the Chief Justiciar of England, was a busy man. King Henry II was raising money for a new crusade, the Third Crusade. It was expensive. Knights needed armor, horses, and supplies. The king needed ships. This required cash and lots of it. Glanville's job was to make the king's law work for everyone, including the king. A knight named Hugh de Lacy came to a lender. Hugh had land, a manor in Kent with fields that produced wheat and pastures that fed sheep. But he did not have 100 silver marks in cash. He needed that money to join the king's campaign in the Holy Land. The lender, a wealthy wool merchant from London, was willing to provide the silver. But he needed security. Charging interest or usury was a sin in the eyes of the church. So they used a different kind of arrangement. It was an old Norman French custom, one Glanville was formalizing in the king's courts. They called it a mortgage. In French, mort meant dead, and gage meant pledge. Hugh de Lacy would hand over his manor to the merchant as a pledge for the loan. The merchant would take all the income from the manor, the rent from the tenant farmers, the profit from the wool sales, all of it. But here was the crucial part. None of that income would be used to pay down the 100-mark loan. The debt remained at the full amount. For the term of the loan, the land was dead to Hugh. It produced no income for him. It did not work to pay off its own debt. If Hugh returned from the crusade and could not produce 100 silver marks on the agreed day, the land was gone forever. It belonged to the merchant. This dead pledge was a clever way around the sin of usury. The lender wasn't charging interest. He was simply taking the profits from the land he held as security. It was a harsh deal. A man could lose his ancestral home, the source of his family's wealth and status, over a single missed payment. Glanville documented this practice in his treatise, Tractatus de Legibus et Consuetudinibus Regni Angli, the first great book on English common law. He laid out the rules for the mortgage. And that term, that concept of a dead pledge, has stayed with us for more than 800 years. It is a piece of the 12th century living in our banks and our courtrooms. Number 10, the law must justify why it holds a person. In the year 1213, a man named William de Braose IV was in a very bad situation. He was a powerful marcher lord, one of the barons who guarded the border between England and Wales. He had been a favorite of King John, but their relationship had soured. King John was a suspicious and cruel king. He demanded hostages from his barons to ensure their loyalty. He demanded William's son as a hostage. William's wife, Maud de Braose, was known for her sharp tongue. In a moment of anger or pride, she refused. She said she would not hand her son over to a king who had murdered his own nephew, Arthur of Brittany. This was a fatal mistake. King John's rage was legendary. He declared William de Braose a traitor. He seized all of William's lands in England and Wales. And William and Maud fled to Ireland with their children, but there was no escaping the king's reach. John sent his loyal enforcer, John de Grey, to hunt them down. William managed to escape to France, disguised as a beggar. Maud and her eldest son, also named William, were not so lucky. They were captured at Galloway in 1210. They were taken to England and brought before the king. He demanded an enormous sum, 40,000 marks, for their freedom and the return of their lands. It was an impossible amount, more than the entire royal income for a year. They could not pay. So King John had them taken to Windsor Castle, and then they were moved to Corfe Castle, a grim royal fortress on the Dorset coast. And there they were locked in a dungeon and left to starve. The official records are silent on their final days, but the chronicles of the time are not. They tell a horrific story of a mother and son left without food or water until they died. This was the world before habeas corpus. A king, or even a powerful lord, could simply take a person. They could imprison them without charge, without trial, without any legal process at all. The prisoner had no recourse. They could be forgotten in a dungeon or secretly killed, and the law had no say in it. The person's body was the property of their captor. This was one of the central grievances the barons had against King John. His arbitrary and cruel use of power was a threat to all of them. If he could do this to the powerful de Braose family, he could do it to anyone. When the barons finally cornered John at Runnymede in June 1215, this issue was at the top of their minds. They forced him to sign Magna Carta, the Great Charter. Chapter 39 of that charter is one of the most famous legal statements in history. It says, "No free man shall be seized or imprisoned, or stripped of his rights or possessions, or outlawed or exiled, or deprived of his standing in any other way, nor will we proceed with force against him, or send others to do so, except by the lawful judgment of his equals, or by the law of the land." This was a direct response to the fate of people like Maud de Braus. It was a promise that the king could not just seize people on a whim. There had to be a legal reason, a process. The tool that grew out of this principle was the writ of habeas corpus ad subjiciendum. It is a Latin phrase. It means, "You shall have the body to be subjected to examination." It was a command from the king's court to a jailer. The jailer, whether a royal sheriff or a private lord, was ordered to bring the prisoner to the court at a specific time. And they had to explain to the judge by what legal authority they were holding that person. The writ did not determine guilt or innocence. It only determined if the imprisonment was lawful. If the jailer could not provide a good legal reason, the judge would order the prisoner released. In the centuries that followed, habeas corpus became known as the Great Writ. It was a fundamental protection against tyranny. It was a way for the central courts to check the power of the executive. A king could no longer make his enemies disappear into a dungeon. He had to answer to his own judges. The principle was simple: the state does not own your body. If it wants to lock you up, it has to stand in a public court and explain why. It has to show its work. The story of William de Braus shows what happens when this principle is absent. For his wife and son were not criminals in a legal sense. They were political pawns. They were disposed of by the king without any legal formality. Their bodies were never produced in a court. No charge was ever formally laid against them. They were simply erased. The terror of that possibility is what gave birth to the writ. It forces the state to be accountable. It brings a person out of the darkness of a cell and into the light of a courtroom. It makes the jailer answer the question, "Why is this person in your custody?" It is a question that is as important today as it was in 1215. The Latin phrase is still used. Lawyers file a writ of habeas corpus, and judges issue it. It is a direct link to the abuses of a medieval king and the barons who decided to stand up to him. Number 9, the law must come to the people. Thomas, a farmer in the county of Lincolnshire, had a problem in the year 1170. His neighbor, a man named Godwin, had moved the boundary stones between their fields. Godwin had taken a strip of land, maybe only 10 paces wide, but it was the best part of Thomas's pasture. It was where the stream ran. Thomas had tried to reason with him. Godwin, a larger and more aggressive man, had just laughed. In the old days, Thomas would have had few options. He could gather his sons and cousins and try to take the land back by force. This would likely lead to a blood feud that could last for generations, or he could appeal to their local lord. But the lord was a busy man, and he happened to be friends with Godwin. He was not likely to rule in Thomas's favor. The legal system was a patchwork of local customs and the whims of powerful men. Justice was often slow, expensive, and uncertain. But things were changing. King Henry II had been on the throne for 16 years. He was a man obsessed with order and control. He had seen the chaos of the Civil War before his reign, a time called the Anarchy. He was determined to create a strong, centralized legal system that would apply to everyone in England. He wanted the king's justice to be the only justice. One of his most important innovations was the general heir, or the assize. The word assize comes from the Old French assise, which means a sitting or a session. It was a court that sat in a particular place at a particular time. But what made it revolutionary was that the court was not fixed in London, right? The court traveled. Henry appointed a group of trusted judges from his court at Westminster. He sent them out in circuits across the country. Every few years, these royal judges would arrive in a county town like Lincoln. Their arrival was a major event. The sheriff would have been notified weeks in advance. He would have summoned knights and freeholders from all over the county to attend. When the judges arrived with their clerks and their guards, they would set up court in the great hall of the local castle or a large church. For a week or two, this traveling court would be the center of all legal and administrative life in the county. This was the assize court, and it dealt with everything. The judges would hear criminal cases. They would use a new method called the jury of presentment. 12 men from each local district, or 100, were put on oath to identify anyone in their community suspected of serious crimes like murder or robbery. This was the ancestor of the modern grand jury. The judges would then try these accused criminals, but the assize judges did more than just criminal law. They also brought the king's civil law to the countryside. Henry II had created a series of new, fast, and effective legal actions for land disputes. These were called the possessory assizes. One of them was called the Assize of Novel Disseisin. It was designed for a situation exactly like Thomas's. Novel disseisin means recent dispossession. It was a simple question, for the court had one person recently and unjustly kicked another person off their land. It didn't get into the complicated question of who had the ultimate right to the land, which could take years to resolve. It just focused on possession. Thomas could go to the royal clerks and buy a writ of novel disseisin for a small fee. The writ would command the sheriff to assemble a jury of 12 of Thomas's neighbors. These were men who knew the land and the people involved. They would be brought before the traveling judges when they arrived in Lincoln. The judges would ask the jury a simple question: did Godwin, without a judgment, and unjustly dispossess Thomas of his free tenement? The jury, under oath, would give their answer. They all knew where the old boundary stones were. They knew Godwin had moved them. And they would say yes. The judges would then issue an order. Godwin would be fined. The sheriff would be instructed to go to the fields and put Thomas back in possession of his land immediately. This was a radical change. For a man like Thomas, justice was no longer a distant and unobtainable thing dependent on the favor of a local lord. The king's court, the assize, had come to him. It offered a quick, affordable, and relatively fair solution to his problem. It was based on the sworn testimony of his own neighbors. This system of traveling judges holding court sessions in county towns continued for centuries. The assize courts were a central feature of the English legal system until they were finally abolished in 1972. The term itself, assize, still echoes in our legal language. The Assize of Clarendon in 1166 and the Assize of Northampton in 1176 were the foundational documents that established this system. They were royal decrees that set out the rules for the judges on their travels. The idea of judges going on circuit is still a part of our system. The concept of bringing the central government's power and law out to the provinces is a direct legacy of Henry II's reforms. It was a way of knitting the country together under a single common law. For a farmer like Thomas, it meant that the king's law was his law too. It was accessible, it was real, and it could get his land back. Number 8. Some crimes are so bad they break the world. In the year 1153, a knight named Gilbert swore an oath of fealty to his lord, the Earl of Chester. He knelt, placed his hands between the earls, and swore to be his man, to defend him and his lands against all others, saving only his duty to the king. In return, the Earl granted Gilbert a small manor with enough land to support his family and a few men in arms. This was the core of the feudal system. It was a world built on personal oaths, on the bond between a lord and his vassal. A man's land, his status, his very identity were all tied to this relationship. Loyalty was not just a virtue, it was the glue that held society together. To break that oath was the most serious offense imaginable. A few years later, a rival baron offered Gilbert more land and more silver if he would switch his allegiance. This rival was at war with the Earl of Chester. Gilbert, tempted by the offer, agreed. In a secret meeting, he planned to open the gates of a small castle he commanded, allowing the rival baron's men to enter and take it. This act of betrayal was discovered. Gilbert was captured by the Earl of Chester's men and brought before the Earl's court. He was not accused of a simple crime. He was not accused of theft or assault. He was accused of felony. Today, we use the word felony to describe a serious crime, more serious than a misdemeanor. But in the 12th century, it had a very specific and terrifying meaning. The word comes from the Old French felon, meaning a wicked or cruel person. In legal terms, a felony was a crime so heinous that it broke the feudal bond between a vassal and his lord. It was an act of profound betrayal. It was a crime that deserved more than just a normal punishment. Your treason against the king was the ultimate felony, but betraying your immediate lord like Gilbert did was also a felony. Other crimes like murder, arson, or rape were also considered felonies because they were such a grave breach of the king's peace, which the lord was supposed to uphold. These crimes destroyed the trust and security that the feudal system was meant to provide. The trial was a grim affair. Gilbert was brought before the Earl and his other vassals. The evidence against him was presented. His betrayal was clear. The judgment was swift. He was found guilty of felony. The consequences were catastrophic, not just for Gilbert, but for his entire family. The first part of the punishment was often death. Gilbert was sentenced to be hanged, but that was not the end of it. The truly devastating part of a felony conviction was something called escheat and forfeiture. Because Gilbert had committed a felony, he had violated his feudal oath. He had broken the bond that gave him the right to his land. Therefore, his land was forfeit. It was not his to pass on to his children. His blood was considered tainted or corrupted. This legal fiction meant that he could not have any legal heirs. His sons and daughters were disinherited. The manor that had been in his family for generations was taken away. It escheated, or reverted, back to the lord, the Earl of Chester. The Earl could then grant it to a more loyal vassal. And it wasn't just the land. All of Gilbert's personal property, his movable goods or chattels, were also forfeit. His horse, his armor, his few silver coins, the very tools from his kitchen, all of it was seized. His wife and children were turned out of their home with nothing. They were cast down into poverty and shame. The felony had not just ended one man's life, it had destroyed his entire lineage. Well, this was the power of the word felony. It was not just a legal category, it was a concept of total social and legal ruin. It was a weapon that lords and the king could use to enforce loyalty. The fear of a felony conviction, the fear of attainder, and the disinheritance of one's children was a powerful deterrent. It shows how deeply the law was intertwined with the social structure of the time. A crime wasn't just an act against an individual or the state, it was a tear in the very fabric of the feudal world. Over the centuries, the feudal system faded away. The specific meaning of felony as a breach of a feudal oath disappeared. But the word remained. It kept its sense of a crime of the utmost seriousness. The old punishments of attainder and forfeiture were eventually abolished. Yes, but the distinction between a felony and a lesser crime, a misdemeanor, became a central part of English and American common law. Even today, a felony conviction carries severe consequences beyond prison time. It can mean the loss of the right to vote, to own a gun, or to hold certain jobs. The word still carries the weight of a serious society-altering crime. It is a ghost of the feudal world, a reminder of a time when the worst crime a man could commit was to betray his lord. Number 7, your neighbors will decide your fate. Agnes, a baker's widow in the town of Northampton, was accused of theft in the year 1194. Her neighbor, a weaver named Walter, claimed that she had stolen a silver brooch from his house. Walter was a respected man in the town guild. Agnes was a widow with little standing. It was her word against his. In an earlier time, her guilt or innocence might have been decided by an ordeal. She might have been forced to carry a red-hot iron bar. If the wound healed cleanly, she was innocent. If it festered, she was guilty, or it could have been decided by trial by combat. She could have hired a champion to fight a champion hired by Walter. The winner of the fight was deemed to be in the right. These were seen as appeals to God's judgment, but the legal world was changing rapidly. The church was growing skeptical of ordeals. And trial by combat was a brutal and uncertain way to find the truth. King Henry II and his successors were promoting a new method, one that was seen as more rational. It was the jurata, or jury. The word comes from the Latin jurare, to swear an oath. A jury was a group of people sworn to tell the truth. The concept was not entirely new. The Normans had used groups of sworn men to gather information for things like the Domesday Book survey. But Henry II adapted it for use in court. At first, it was used mostly in land disputes, but by the time of Agnes's accusation, it was beginning to be used in criminal cases as well. The local sheriff was ordered to assemble a group of 12 of Agnes's neighbors. These were not strangers chosen for their impartiality as we would expect today. They were chosen for the exact opposite reason. They were chosen because they knew Agnes, they knew Walter. They knew the town. They were expected to know the facts of the case already, or to be able to find them out easily. They were a combination of witnesses and judges. The trial took place when the king's traveling judges held their assize in Northampton. Agnes and Walter were brought before the judge in the great hall of Northampton Castle. The 12 men of the jury were called. They stood before the judge and took an oath to speak the truth. Walter told his story. He described the brooch and when he had last seen it. He explained why he suspected Agnes. Perhaps someone had seen her near his house. Perhaps she had recently come into some money. Then Agnes was allowed to speak. She denied the charge. She explained that she had been at the market all day. She might have brought forward other neighbors to speak for her character. There were no lawyers in the modern sense. There were no complex rules of evidence. It was a much more direct and personal affair. After hearing from both sides, the judge would turn to the jury. He would ask them for their verdict. The word verdict comes from the Latin verdictum, meaning a true declaration. The 12 men would confer. They would talk among themselves in a corner of the hall or perhaps outside. They would pool their local knowledge. One might know that Walter was a notorious gambler and was short of money. Another might know that Agnes was an honest woman who had never been in trouble before. A third might have heard a rumor that the brooch had actually been stolen by a traveling peddler. They were not just weighing the evidence presented in court. They were conducting their own investigation based on what they already knew about their community. After a time, they would return. Their foreman would announce their verdict. Not guilty, he might say. And that was that. The judge would declare Agnes free to go. Or they might say guilty. In that case, the judge would pronounce the sentence. For the theft of a silver brooch, the punishment could be severe. Agnes could be fined, or put in the stocks, or even branded or whipped. This was the early trial jury. It was a revolutionary idea. It took the judgment of a case out of the hands of God through ordeal or brute force, through combat, and put it into the hands of a person's own community. It was based on the idea that the people who lived in a place were the best ones to judge what happened there. It was a deeply local form of justice. Of course, it was far from perfect. It could be subject to local prejudices, rumors, and personal feuds. A powerful man like Walter might be able to influence the jury. A poor widow like Agnes was at a disadvantage. But it was still a major step forward. It was an attempt to base a legal decision on what a group of sworn, ordinary people believed to be the truth. Over the next several hundred years, the role of the jury continued to evolve. Jurors gradually stopped being witnesses who were expected to know the facts beforehand. They became impartial arbiters who were supposed to know nothing about the case until the evidence was presented to them in court. But the core principle remained the same. A group of a defendant's peers, their neighbors in a broader sense, would be the ones to decide their guilt or innocence. That idea, born in the legal experiments of the 12th century, is still a cornerstone of our justice system. Number 6. Your worth can be measured in cattle. Robert Fitzwilliam was a moderately successful farmer in Suffolk in the year 1250. When he died, his will became a source of conflict for his family. The will was clear about the land, his small farm, the fields, the cottage, and the barn. All of this went to his eldest son, Richard. This was the law of primogeniture. Land was a source of real wealth and status, and it was kept intact by passing it down to one heir. This type of property was called real property or realty. It was fixed, immovable, but Robert had owned other things besides land. He had 2 oxen that pulled his plow. He had a half-dozen cows, a flock of sheep, and a cart with a horse to pull it. Inside his house, there was a heavy wooden table, some stools, iron cooking pots, and a locked chest that contained 10 silver shillings. All of these things were his personal, movable possessions. The law had a special name for them. They were called chattels. The word chattel came into English from the Old French, but its ultimate root is the Latin word capitale, which meant head or principal. This Latin word also gave us the word capital in the financial sense. But in medieval times, the most common form of movable wealth, the principal form of capital, was livestock. Heads of cattle. So the word chattel became synonymous with movable property, with its origin in the word cattle. The 2 words are in essence the same. In Robert's will, he had left his chattels to be divided between his younger son, Thomas, and his daughter, Eleanor. This was a common practice. The heir got the land, the other children got the movable goods, but the division was not simple. What was a cow worth compared to an ox? How many sheep equaled the value of the horse and cart? Was the silver in the chest to be split first, or was it part of the general pot? These were the questions that brought Thomas and Eleanor to the manorial court. The court, presided over by the lord of the manor's steward, had to decide the value of Robert's chattels. It was a tangible accounting of a man's life's work aside from his land. The clerk of the court would make a list and inventory. 2 oxen, 6 cows, 20 sheep, 1 horse, 1 cart, 1 table, 4 stools, 3 iron pots, 10 shillings. Each item was a chattel. The court had to determine a value for each and then ensure the division was fair according to the will. This distinction between real property land and personal property chattels was fundamental to medieval law, and it remains a core concept in law today. The rules for how you could own, sell, inherit, and be taxed on these 2 types of property were completely different. Land was permanent. It was tied up in the complex web of the feudal system. It was about lineage, duty, and power. Chattels were transient. They were a person's private wealth. They could be bought, sold, or given away much more easily. The word chattel also had a darker side because it meant a piece of personal, movable property. It could be applied to anything that was owned. For much of history, this included human beings. Slaves were legally defined as chattels. They were not considered persons with rights, but as property, like a horse or a table. They could be bought and sold. They were listed in inventories of estates alongside the livestock and the furniture. This legal classification of people as property, as chattels, was a necessary step in justifying the institution of slavery. The phrase chattel slavery is a direct and chilling reminder of this history. It means a person is owned as an object, a thing, a piece of movable property. So, when we see the word chattel in a legal document today, it connects us to 2 very different parts of the past. It takes us back to a simple agricultural world where a man's wealth was counted in his heads of cattle. It is a practical term used in wills and contracts to describe our stuff, our cars, our furniture, our bank accounts. But it also carries the heavy memory of a time when the law used this same word to deny people their humanity. It is a simple word with a complex and often painful history, born from the fields and farms of the 12th century. It's number 5. A promise can be your prison or your freedom. In the year 1199, a London merchant named Thomas of Fleet was arrested. He was accused of being in debt to a wine importer. The sum was significant, 20 pounds, and the importer had convinced the sheriff that Thomas was a flight risk. Thomas was taken to the Fleet prison, a notorious and miserable place on the banks of the Fleet River. In the 12th century, there was no presumption of innocence that kept you out of jail until trial. If you were accused of a crime or a serious debt, you were often locked up to ensure you would show up for your court date. This could be a disaster. A merchant like Thomas could lose his business. A farmer could miss his harvest. A man could languish in a disease-ridden jail for months or even years before his case was heard. Thomas had a way out. It was a process called bail. The word comes from the Old French verb bailler, which means to give or to deliver. Bail was a system of conditional release. A prisoner could be delivered from the custody of the jailer into the custody of other people who would be responsible for him. These people were called sureties. Thomas sent a message to the guild of which he was a member. A few days later, 2 of his fellow merchants, respected men with property in the city, came to the court of the king's bench. They stood before the judges and offered to stand as sureties for Thomas. This was not a simple promise. It was a solemn and legally binding act. They were making a pledge, a bond. They were guaranteeing that Thomas would appear in court on the appointed day to face the wine importer's claim. If Thomas showed up, their obligation was finished. But if Thomas fled, if he ran away to France or disappeared into the English countryside, his sureties would be in serious trouble. The court would come after them. They would be forced to pay Thomas's original debt of 20 pounds, and they might face additional fines or even imprisonment themselves for failing in their duty. They were putting their own property and liberty on the line. Their promise was the collateral. The judges considered the offer. The sureties were known to be reliable men. The crime was a civil debt, not a violent felony. The judges agreed to grant bail. They set the date for the hearing 3 months away. A document was drawn up, a recognizance which recorded the surety's pledge. Thomas was then released from the Fleet prison. He was not completely free. He was in the custody of his sureties. They were his jailers, in a sense. It was their job to, keep an eye on him and make sure he did not disappear. This was the original meaning of bail. It was not about money posted by the accused. It was about other people, the sureties, making a promise to the court. It was a system built on community and personal reputation. A man with strong connections, with friends or family willing to vouch for him, could get out of jail. A stranger or someone with a bad reputation would have no one to stand for him and would be left to rot. The system of using sureties was essential in a time before modern police forces or sophisticated tracking technology. The court relied on the community to police itself. The sureties had a powerful financial incentive to make sure the accused did not abscond. This practice of relying on sureties continued for centuries. It was only much later that the modern system of a cash bail bond, often paid to a commercial bail bondsman, began to develop. The core idea of bail, however, has remained the same for over 800 years. It is a trade. A defendant's liberty in exchange for a guarantee that they will return to court. The word itself, bail, is a piece of that medieval world. It speaks of a time when justice was personal, when a man's freedom depended on the willingness of his neighbors to deliver him from a jail cell and take responsibility for him themselves. When a judge today sets bail at a certain amount, they are continuing a practice that would have been recognizable to Thomas of Fleet and the two friends who pledged their own fortunes to get him out of a 12th century prison. Number 4, the land remembers its owner. John Maltravers was a minor lord in Dorset who died in the year 1220. He held his land from a greater baron who in turn held it from the king. And John had lived a full life, but he had outlived all of his children. He had no sons, no daughters, no grandchildren. His brothers were long dead and they had left no issue. His family line had come to an end. This created a legal problem. Who would inherit his land? Under the feudal system, land was not owned outright in the modern sense. A person held land as a tenant from a lord in exchange for services, usually military service. The right to hold that land passed down from generation to generation through the bloodline. But what happened when the bloodline ran out? The law had a clear answer and a specific name for it. The land would esquite. The word esquite comes from the old French word esquire, meaning to fall out or to happen. In a legal context, it meant that the land would fall back to the lord who had originally granted it. Because John Maltravers had no legal heirs, his tenancy ended. The land he held reverted to the baron from whom he held it. It was a windfall for the baron. He was free to grant the land to a new tenant, creating a new feudal bond and securing the loyalty of another knight. The escheat was a fundamental part of the feudal land-holding system. It ensured that land never became ownerless. The land always had a lord. It was a legal safety net for the powerful. It was one of the many feudal incidents, the rights that a lord held over his tenants, which also included the right to control their marriages and to take them into wardship if they were minors. These rights were a major source of income and power for the nobility and the king. There was another way that escheat could happen, and it was much more dramatic. It could happen through a felony conviction. Let's say John Maltravers had a son, and that son was convicted of treason or murder. As we saw with the concept of felony, such a crime corrupted the blood. The son's blood was attainted. The law said that this corrupted blood could not inherit. So, even though there was a direct heir, he was legally barred from receiving the land. The land would therefore esquite to the lord, just as if there had been no heir at all. This was a powerful tool of social control. The threat of escheat was a strong incentive for a lord's vassals to remain loyal and law-abiding. If they stepped out of line, they risked not only their own lives, but the complete destruction of their family's fortune and future. The land would be lost to them forever. The crown, as the ultimate lord of all land in the kingdom, was the biggest beneficiary of escheat. The king's officials kept careful records of family lines and land holdings. When a tenant-in-chief, someone who held land directly from the king, died without an heir, vast estates would escheat directly to the crown. This was a significant source of royal revenue. The king's men, known as escheators, were appointed in every county to look out for these opportunities and to manage the lands that fell back into the king's hands. The feudal system has long since vanished. We now think of land ownership in much more absolute terms, but the doctrine of escheat has survived in a modified form. Today, if a person dies without a will and with no known relatives who can be traced, their property does not become a free-for-all. It eschates to the state. The government becomes the owner of last resort. Every state has a law of escheat. This is why banks have to turn over dormant accounts to the state after a certain number of years. It is why the property of someone who dies intestate and without heirs goes to the government. The modern principle is different. It is no longer about preserving the feudal structure. It is about the orderly administration of property and preventing it from becoming ownerless. But the name and the basic legal mechanism is a direct inheritance from the 12th century. It is a time-traveling concept from a world of knights and barons, a world where land was everything, and the law ensured that the land always remembered its ultimate lord. Number 3. You must come to court, or else. A dispute over the ownership of a mill in Essex reached the King's Court at Westminster in the year 1285. The plaintiff, a man named Roger, claimed that the mill had belonged to his father and that the current owner, a powerful local knight named Sir Geoffrey, had seized it illegally. Roger's case depended on the testimony of an old man named William, who had served as the miller for both Roger's father and for Sir Geoffrey. William knew the history of the mill better than anyone. He had seen the documents. He knew who had paid the taxes. He was the key witness, but William was terrified. Sir Geoffrey was a powerful and violent man. He had made it clear that if William testified against him, there would be consequences. His cottage, which was on Sir Geoffrey's land, would be taken from him. He might even suffer physical harm. So when the time came for the hearing, William stayed home. He told Roger he was too ill to travel to London. Without his testimony, Roger's case was likely to fail. The English legal system was growing more sophisticated. It was moving away from trial by ordeal and combat and towards a system based on evidence and testimony. But this new system depended on the willingness of people to come to court and speak the truth. What could the court do when a witness was too scared or too stubborn to appear? The answer was a powerful legal document called a writ, and one of the most powerful writs was the subpoena. Roger's clerk went to the Court of Chancery, the King's Secretariat, and paid a fee to have a writ of subpoena issued. The word is Latin. It means under penalty. The writ was a formal command from the king himself. A royal messenger on horseback carried the sealed parchment from London to William's small village in Essex. Well, he delivered it directly to the old miller. The text of the writ was formal and intimidating. It commanded William to appear before the king's judges at Westminster on a specific day to give testimony in the case between Roger and Sir Geoffrey. And then came the crucial phrase, sub poena centum libram, under penalty of £100. This was an enormous sum of money, enough to buy a large farm. It was a fortune that a man like William could never hope to pay. Failure to comply could also result in imprisonment for contempt of court. The writ put William in an impossible position. On one hand, he faced the wrath of his local lord, Sir Geoffrey. On the other, he faced the immense power of the king's central government and the threat of financial ruin. The subpoena was a direct assertion of the royal court's authority over every subject in the land, no matter how humble. It said that the court's need for evidence and truth was more important than a local lord's power to intimidate. It was a legal tool designed to pry reluctant witnesses out of their homes and compel them to testify. William, faced with this choice, decided that defying the king was a greater risk than defying Sir Geoffrey. He made the long journey to London. In court, under oath, he testified about the ownership of the mill. He told the truth. Based on his testimony, the court ruled in Roger's favor. Sir Geoffrey was forced to return the mill. The subpoena became an essential tool of the common law. It developed into two main types. The subpoena ad testificandum, which is what William received, commands a person to appear and give testimony. The subpoena duces tecum bring, with you under penalty commands a person to produce documents or other physical evidence in court. This simple Latin phrase, under penalty, is still on every subpoena issued by a court today. It is a fundamental part of our legal process. It gives courts the power to gather the information they need to make a decision. Without it, a legal system based on evidence could not function. People would only testify when it was convenient or when they were not afraid. The subpoena forces them to participate. It is a direct and powerful legacy of the medieval English kings' determination to make their courts the supreme legal authority in the land. an authority that could reach into any village and command any person to come and speak the truth, under penalty. Number 2, the blood decides everything. In the year 1135, King Henry I of England died after eating a surplus of lampreys. His death plunged the kingdom into a devastating civil war that lasted for nearly 2 decades. The conflict was known as the Anarchy. The cause of this chaos was a dispute over a single legal concept: who was the rightful heir. The word heir comes from the Old French heir, which in turn comes from the Latin heirs. It means one who is legally entitled to inherit the property or rank of another. For the English throne, the rules of inheritance were still in flux. Henry I had a legitimate son, William Adelin, who was his undisputed heir. But William had tragically drowned in the White Ship disaster of 1120. This left Henry with only one legitimate child, a daughter named Matilda. As before his death, Henry I had made his barons swear an oath to accept Matilda as his heir and the future Queen of England. This was a radical idea. A woman had never ruled England in her own right. The barons had sworn the oath, many of them reluctantly. When Henry died, their promises were put to the test. A rival claimant appeared. He was Stephen of Blois, Henry I's nephew. His claim was through his mother, Adela, who was a daughter of William the Conqueror. Stephen argued that he was a more suitable heir because he was a man. He was a known military leader. He rushed to England, seized the royal treasury, and had himself crowned king. Many of the barons who had sworn to support Matilda broke their oath and backed Stephen. They believed that a male heir, even one with a weaker blood claim, was preferable to a female ruler. What followed was a brutal and destructive war. Matilda invaded England with the support of her half-brother, Robert of Gloucester. For years, the country was torn apart. Armies marched back and forth. Castles were besieged. Villages were burned. Law and order broke down completely. The Anglo-Saxon Chronicle captured the horror of the time. Men said openly that Christ and his saints were asleep. This entire conflict, which caused immense suffering and set England back for a generation, was a battle over the meaning of heir. Was the heir the person with the most direct bloodline, regardless of gender, Matilda, or was the heir the most suitable male relative, Stephen? The law was not yet strong enough to provide a clear answer. For ordinary people, the concept of the heir was just as important, though on a smaller scale. Under the rule of primogeniture, which became firmly established during this period, the heir to a landed estate was the eldest legitimate son. When a knight or a baron died, his eldest son inherited everything: the castle, the lands, the titles, the feudal obligations. This was done to keep the family's power and property consolidated. A divided estate was a weak estate. This had profound consequences for society. The heir, the eldest son, was the center of the family's future. He was raised to rule. His younger brothers were left with nothing. They had to make their own way in the world. They could become knights in the service of another lord. They could join the church and hope to rise to become a bishop or an abbot. Or they could go on crusade, seeking fame and fortune in a distant land. The literature of the time is filled with the stories of these landless younger sons. The figure of the heir and the dispossessed younger brother shaped medieval family dynamics and politics. The law of the heir was rigid. It was all about the legitimacy of the bloodline. A bastard son, even if he was the eldest and most capable, had no right to inherit. He was filius nullius, the son of no one. This obsession with the bloodline and the legitimacy of the heir was the source of countless personal tragedies and political conflicts. Eventually, the anarchy in England was resolved by a treaty. It was agreed that Stephen would rule for the rest of his life, but that Matilda's son, the future King Henry II, would be his heir. This treaty, the Treaty of Wallingford, finally settled the dispute. When Stephen died in 1154, Henry II took the throne peacefully. One of his great tasks was to rebuild the kingdom and create a legal system so strong that a succession crisis like the anarchy could never happen again. He strengthened the laws of inheritance, making the rights of the heir clearer than ever before. The word heir is still a fundamental legal term. It is at the heart of our laws of inheritance and succession. Wills and trusts are all about designating heirs and specifying what they will receive. While the rules have changed, allowing for female heirs and more equal division of property, the basic concept is the same. The heir is the person designated by law or by a document to receive property upon another's death. It is a word that carries the weight of history, a reminder of a time when the question of who is the rightful heir could plunge an entire kingdom into war. Number 1. You must have a complaint to begin a case. In the year 1230, a woman named Isabella arrived in London. She was a widow from a small village in Yorkshire. Her husband had held a small piece of land from a local knight. When her husband died, the knight seized the land, claiming it should have reverted to him. Isabella believed that, by local custom, she had the right to hold the land for the rest of her life, a concept known as dower. The knight had more power and more men than she did. She could not fight him physically. Her only hope was the law. But in the 13th century, you could not simply walk into a court and tell your story. The king's justice was a formal and complex system. To begin a case in the royal courts, you first needed permission. You needed to have a specific, recognized legal complaint, and you needed to purchase a document from the king's officials to prove it. This document was called a writ, and the person who bought the writ, the person who was making the complaint, was called the plaintiff. The word plaintiff comes to us directly from the old French word plaintif, which means complaining. It is related to words like plaintive and complain. The plaintiff was, quite literally, the complainer. Isabella, the widow, was the plaintiff. She was the one with the grievance, the plaint. Her journey to seek justice was long and difficult. She had to travel from Yorkshire to the Court of Chancery in London. There, surrounded by busy clerks, she had to explain her situation. The clerk would listen to her story and decide if it fit one of the established legal formulas. The system was rigid. If your problem did not match a pre-existing type of right, you were out of luck. There was a saying, no right, no remedy. Fortunately for Isabella, her problem was a common one. There was a specific writ for widows seeking to recover their dower lands. It was called the writ of dower unde nihil habet whereof. She has nothing. For a fee, the clerk would carefully write out the writ on a piece of parchment using precise and unchangeable Latin phrasing. He would then affix the king's great seal to the bottom of the document. This was Isabella's ticket into court. The right was a command from the king to the sheriff of Yorkshire. It instructed the sheriff to order the knight to give Isabella her land. If the knight refused, the sheriff was to summon him to appear before the king's judges at Westminster on a certain day to explain why he had not complied. The right initiated the entire legal process. Without a plaintiff like Isabella to purchase that right, the court could do nothing. Being a plaintiff was not easy. It required time, money, and persistence. Isabella had to pay for the writ. She had to pay for a messenger to take it to the sheriff. She would likely need to hire someone, an early form of a lawyer, to speak for her in the formal French-speaking court. She was the engine of the case. She was the one pushing it forward at every stage. If she gave up, the case would simply disappear. The defendant, the person being complained against, was in a reactive position. The knight in Yorkshire had to respond to the writ. He had to show up in court, but the burden was on the plaintiff, Isabella, to prove her case. She had to bring her evidence, her witnesses who knew the local custom, to convince the judges that her complaint was valid. This adversarial system where the plaintiff who complains and a defendant who defends was born in these medieval courts. And it is the foundation of our civil justice system today. Every lawsuit starts with a plaintiff, a person or entity that files a formal complaint with a court. That complaint, like Isabella's writ, sets out the grievance and the legal basis for the claim. It is the document that forces the defendant to respond and sets the legal machinery in motion. The word plaintiff itself is a perfect example of a legal time traveler. It is a simple descriptive word rooted in the human act of complaining. It reminds us that at the heart of every complex civil case, there is a person or a group of people who believe they have been wronged and are seeking a remedy from the law. It connects a modern corporation filing a lawsuit for breach of contract with a determined widow, like Isabella, traveling hundreds of miles on foot or by cart to buy a piece of parchment that held her only hope for justice. She was the plaintiff. She was the complainer. And because of her complaint, the law was forced to act.